For over 100 years, corporations were restricted in how they could speak out concerning political elections. At least some of that has now changed. We'll talk about corporations and the political process right now on The Law Works.
From West Virginia Public Broadcasting.
The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
On January 21, 2010, the United States Supreme Court decided the case of Citizens United versus the Federal Election Commission and declared certain restrictions on the role of business corporations in elections unconstitutional. My guests are WVU law professors James McLaughlin and Robert Bastris. Jim, Bob, thank you for joining us again.
To be here.
You guys are getting to be regulars here. What is this case about, Citizens United versus the Federal Election Commission? What were the issues that led to this case?
Well, the primary issue was whether Congress could prohibit the corporations, both profit and nonprofits, from electioneering in 30 days prior to a primary or 60 days prior to a federal general election. And at issue was just the independent expenditures of corporations, not contributions to candidates, which were not affected by the case.
So this was whether ExxonMobil or Fred's Appliances could spend money
on their own to either support or run against a particular candidate, a named candidate.
And the major factual event that occurred was a film about Hillary Clinton.
About Hillary Clinton. It was a full-length film and was distributed primarily through video demand or something to that effect, and was extremely critical of Hillary and was clearly a quote, documentary designed to try to defeat the presidential candidacy of Hillary Clinton.
I never saw the film. Did you see it, Bob?
No, I did
Jim,
not.
Did you see it?
I've seen parts of it, yes,
Okay.
at the SEALs convention last year.
Primarily, it wasn't seen by anybody because the Federal Election Commission said, no, you
can't do it.
show it.
That's right.
And after the election, it didn't make any difference anyway. But it was, as you say, Bob, a documentary that cast her in an extremely negative light.
Yes, it did.
And of course, the producers of the film would say it was simply factual, and people who were Hillary supporters would say it was a character assassination.
Right. It was mostly, at least as described in the court's opinion, it was primarily people stating opinions about Hillary Clinton and bringing to the fore the fact that electing her would establish a sort of Bush-Clinton dynasty, and that this country has always resisted dynasties, and it's more or less expressions of that kind of opinion.
Yeah, the court keeps saying it was pejorative, but it was not that pejorative, frankly. I saw the thing, and it's not that bad.
Well, the interesting thing about it is it did not say overtly, don't vote for this woman, nor did it overtly say, vote for somebody else.
That's right.
As I understood it.
Right.
But the people who made the film, Citizens United, which was a non-profit corporation of people who wanted to see this film produced, got together, produced it, said we'll distribute it, at least in major part, on cable television with video on demand. But it neither advocated for someone else nor against her. But the producers said, you know, the law looks like this might be even a criminal act. If we do this, we had better ask first. And so they filed a federal court action.
Right, right. Under the definition of electioneering as defined by the Supreme Court in a case a couple years ago, advertisement is electioneering if it names the candidate and it's clear that the message being sent is either for or against that named candidate.
Yeah, the impact was this woman is not worthy of holding the office
Correct.
she's running for,
Correct.
which was in fact president.
Right. And I don't think the court had any problems with characterizing that as an electioneering film.
No, in fact, Citizens United asked whether it was an electioneering film, and Chief Justice Roberts wrote the majority opinion, just kind of cast those kinds of concerns aside and said they were relatively insignificant in the context of the bigger question.
Right. Right, yes. They went right to the main issue in the case as to whether Congress could limit that kind of what they call independent expenditure, spending on an election, unrelated to any, or without any relationship with the candidate himself or herself.
Spending out of their own treasury,
Right.
Out of the monies of the corporation, as opposed to what Congress had set up was this political action committee option for corporations in which they put money into a separate, I guess it's not a corporation, but it's a separate,
It's a political action committee.
it's a separate organization, and that's how Congress thought corporations ought to speak to the public through their PACs, PACs, or PACs, or what we all have come to know about.
How did that work? Was there any limit on what a corporation could put into a political action committee?
No. There were limits as to what the PACs could do. They could only contribute so much to any one particular candidate. But the corporation would set up these PACs. The corporation could put some of its own money in there. Its officers could contribute, and of course other people could contribute as well. And then the PAC would decide how the money would be distributed. And there were reporting requirements, disclosure requirements as to where the money went, where it came from, and then there were caps on how much the PAC could give to a particular candidate.
But the PAC could speak in its own behalf.
Well, it could make the decision about where to spend the money. And it's speaking on its own behalf. It could also engage in independent expenditures, yes.
Well, it seems as though that we've created not only a hole in the campaign financing laws, but a huge gateway. What's the difference between letting the corporation speak out on its own and creating this other entity that is, I'm going to call it a puppet of the corporation, if the corporation wants it to
Well,
be?
there are a lot of restrictions on PACs that would not apply to what is now the corporate right to engage in independent expenditures. It's expensive to manage these things. There are only 2,000 corporate PACs in the country, despite the fact there are over 5 million corporations, for-profit corporations. That doesn't even count the nonprofits. It's extremely difficult for nonprofits to set up PACs. And so the PAC alternative did not exist for most corporations as a practical matter.
The Supreme Court was pretty well divided in this case.
Very much so.
The numerical terms 5-4, but there were a number of other opinions. There were 3 concurring opinions. A concurring opinion is an opinion that supports the majority opinion, but for perhaps different reasons or has different takes on the reason, and whoever the justice is decides to write it out that way. So there were 3 concurring opinions, and then there was what I would style as a dissenting opinion for the 4 justices that voted the other way, but it was also concurring in part.
Right. Well, he concurred on the questions as to whether Congress can require disclosure, that if a corporation engages in speech, that Congress can require them to identify the corporation, who the speaker is, and where they got their money, and that sort of thing.
So that still stands.
Yes.
And the
And
limitation,
that was unanimous, really.
yeah, and the limitation on campaign contributions still stands.
Right.
Then that's on people, and that will be on corporations. But it does mean that a corporation probably now can give up to $1,000 to any particular candidate.
Well, I don't know that you can say that. It might make an argument that corporations also cannot be prohibited from engaging in that form of political speech by giving money directly to candidates, but
More than 1,000, more than what a person can give?
no, not more. I don't think corporations currently cannot give at all.
I know, but
And they'd have to do that through a PAC. And I don't think this case changes that.
But
yet.
now corporations can contribute to candidates, which they couldn't do before, but they also have the right to speak with their own voice.
They have the right to speak with their own voice, yes.
right, without going through the PAC. And the PAC has administrative costs, and according to Kennedy and Roberts, it's not really a very practical thing. It stifles speech because it costs so much to set them up. As Bob says, there are only 2,000 of them?
That's what the opinion says, yeah.
Well, and I suppose that's one of, if not the major issue in the case is this stifling of speech. What is that about?
Well, there's a whole lot of speech that corporations cannot engage in. And when you think about the time periods here, we're talking about 60 days before primary. You know, when Hillary came out, it was in late, well, they were ready to distribute it in late December of 2007. And by January of 2008, you were within 30 days of a primary. And so that Hillary could not be distributed for virtually all of 2008 because there was always some sort of primary going on, and of course 60 days before the general would take it back to September. So there was a significant period of time in which corporations could not contribute their 2 cents to elections.
And the basic law was you cannot distribute this film, or you cannot engage in this speech within 30 days of a primary election where the film was going to be distributed or exhibited.
I assume that's correct.
Could a PAC?
Yeah, a PAC could do that.
A PAC, so they could have done, why didn't they in this case do it through a PAC?
Well, I think they wanted to challenge the law.
Okay,
Which they
wanted
did.
to make a test case out of it.
Yeah.
But what they did, the way they challenged the law was I think they got more than they intended to get, because they were just essentially prohibited. The first federal court that it went to said, nope, you can't do that. They were prohibited from distributing the film, which was not what they intended. I think they probably thought they were going to be allowed to distribute it.
Right. There were indications in some prior cases that the court might be ready to do this. It wasn't really a big surprise to me, at least. But the court did set it for re-argument. The lower courts had decided it on a slightly different issue, and then it was appealed on that basis. The court heard argument and then asked for re-argument on whether the law itself was constitutional. That is, the ban on independent expenditure. So it's a much broader opinion than had occurred in the lower courts.
Or that anybody wanted in the lower courts. Well, at least that the producers of the film wanted.
Right. Well, there was a prior U.S. Supreme Court case going the other way. It had to overrule a 1990 decision. And so the lower courts, of course, could not overrule a Supreme Court case. Only the Supreme Court could do that.
But the overriding issue was that by telling these corporations that they could not engage in this kind of speech within these time periods had what is referred to as a chilling effect on free speech. And the majority opinion says that because the producers felt that they had to go get the court's permission to do this, to distribute this film, they would be reluctant, or others would be reluctant from speaking out.
Right. Well, the Federal Elections Commission said you can't do it, and if they'd have gone ahead and done it, they would have been exposing themselves to a criminal liability.
And even if they had won, the defense would be expensive, and that too would be a chilling effect.
Right.
Chilling effect.
Absolutely.
Chilling effect means basically you're freezing someone out of the process. And in this case, the argument was if corporations are not allowed to speak on their own behalf in these political matters, they're being frozen out of the electoral process. Their free speech rights are being frozen, and they don't get to participate. And elections are important.
Right. They're discouraged from even engaging in the speech in the first place because of the existence of the criminal laws.
The more recent law, the what is it? McCain-Feingold Bipartisan Campaign Reform Act was what passed in 2000, and based on a big study that Congress had done, including 1996 report in 6 volumes by one of the committees of Congress. And then all of this came out because they saw everybody was bypassing their original act and and doing things that they thought made it appear as if Congress was for sale. And was bought by these big interests, etc. And so this act, McCain, of course, the guy who ran for president,
John
McCain, and Feingold, who is a Democrat, sponsored this bill, and that's why, and it is a bipartisan bill. And there was thousands of hours put into creating this bill, and by a 5-4 decision, the Supreme Court strikes a good bit of it down, or some important parts of it, at least as opposed to corporations. And in fact, had Justice O'Connor's husband not gotten sick, which occasioned her resigning from the court, it might well be that the vote would have been 5-4 the other way, because although she had dissented in that first case, the Austin case, that had upheld limits on corporations, she had written the opinion in McConnell, which is the case that the court that upheld Feingold and which the court struck down part of.
So you mean personalities of the justices determine how cases are decided?
Well, when it's 5-4, you don't. But Kennedy is
their personal values certainly come into play because it was fairly predictable how it would come out.
Yeah, but it's both a political philosophy and a judicial philosophy that they have. The judicial philosophy is, for Kennedy, for instance, a little more literal about what speech is, and the other and less deferential to Congress. O'Connor and Stevens, in their opinion in the McConnell case, said that this is a situation where we should defer to Congress's judgment on this as to how to control these things, because they have more experience, etc. And so, there's a judicial philosophy. Do you defer, give a benefit of the doubt to Congress or not? And I think the 5 that voted to strike this do not have much in the way of thinking there should be deference.
The 4 dissenters don't hesitate to strike down acts of Congress when they feel that the situation is appropriate, and I'm not sure that they're any more deferential ordinarily to Congress than those who are in the majority. I mean, I think it's a case in which I said it was predictable in that the 5 in the majority have made it quite clear that they don't believe there's such a thing as too much speech, and that efforts to limit campaign participation and to engage in what is core political speech. And we're talking about the very heart of the First Amendment, talking about elections. I mean, that's the base of democracy.
And the opinion says that.
Yes, and to say that a sizable segment of our society, that all profit and all non-profit corporations and all unions cannot engage in speech about an election in the period immediately before an election is a fairly broad and remarkable restraint on core political speech.
Well, one of the threshold legal issues is what are corporations? It's a question of what are corporations. And historically, do we not say corporations are people too?
Well, we do in some contexts. I think it's been around for quite some time that corporations have rights as well. They're not necessarily coextensive with individual rights, but they certainly have rights as entities, and they're major players in our society. I mean, corporations lobby heavily in Congress, as do other individual interest groups. And that's certainly participating in our political system, and I think that this court is saying they have a right to participate in the electoral system as well.
They have equal protection rights and due process rights since the court just declared it as a kind of in passing in 1886. They say, oh yeah, they're persons within the meaning of the 14th Amendment.
Well, we have many laws that talk about natural persons, which would be people like the 3 of us and you out there, and artificial persons. And artificial persons are corporations, partnerships, limited liability companies, and that sort of thing. And the Constitution just says you don't abridge freedom of speech. You don't deny rights of religion. I suppose a corporation could have a religion if they wanted to.
Well, there are religious corporations, for sure.
Yeah.
We don't allow them in West Virginia, but of course that's unconstitutional as can be.
Case to be decided later.
We come up with fictions to get around that provision, but certainly you're right about the First Amendment. It's written in terms of Congress shall make no law abridging the freedom of speech or of the press, and it does not restrict itself to in at least its literal language, to individuals.
Well, one of the things that I found interesting in the majority opinion, there was a distinction made. He said, well, wealthy individuals can say what they want to. They can buy ads. They can make movies if they want to. But wealthy corporations can't, and it's unfair to distinguish between wealthy individuals and wealthy corporations.
Well, I don't know if it was so much a concern about rights of corporations that provoked the holding in the case. I think it was more about the limits, the extent to which we're just stifling and eliminating a whole chunk of speech. And the fact that it happens to be a limitation on corporations it wouldn't have mattered if it were the other way around. I don't think that if it limited individual speech rather than corporations, I think the majority would have been just as eager to step in. So I don't see it as necessarily protecting corporations as much as it is protecting political speech.
And that's consistent with Powell's opinion in Bellotti.
Right, which was the first major case dealing with corporate speech.
And how did that come out?
The court it dealt with a provision in Boston, Massachusetts that said corporations could not participate in any election that did not involve its own corporate tax or its own policies, and the court said that's unconstitutional because that corporations might have something relevant to say on any subject.
So in that case, a corporation was prohibited from speaking about things other than its own personal interests.
Right, right.
And I think Justice Stevens concurred in that opinion.
I believe you did.
Yeah, but that opinion was essentially undermined in Austin, in which had the dissent of Scalia and O'Connor and Thomas. And Rehnquist at that time was voted with the sixth.
Well, what did Austin say?
Austin said that the state of Michigan could limit the contributions of corporations from their own treasury, except in some special circumstance. I mean, they upheld that.
Yeah, although over half the states permitted corporate independent expenditures prior to this case.
So this case necessarily had to overrule some other decisions.
It overruled the Austin case and explicitly did so. It did not try to dance around Austin. It flat out overruled it.
So what does all this mean for the future? What are we going to see in the next election cycle?
Well, I think we'll see more direct participation by corporations and unions. I would expect that. In my view, it'll just be more speech. And, you know, we get so concerned in this country about, we're spending all this money on elections and on advertising for elections and so forth. But it seems to me it's all, and, you know, that's what democracy's about. We spend a lot of money on advertisements for shampoo and toothpaste, too. But nobody seems to get upset about that. And I'm not sure what the problem is with having a lot of money invested in elections.
Corporations, like individuals, still will not be allowed to directly contribute to candidates more than, well, not at all, I guess, right. But not at least more than the $1,000 that is the limit on individuals.
Actually, it's $2,000 for federal elections.
It's gone up now.
Yeah.
It's $2,000 in federal elections.
You know, that's kind of seems like small potatoes. If Jim or Bob, if you're running for office and I'm a corporation or I'm in charge of a corporation and I like you and I don't like you, I can give you $1,000 and that pays for a couple of billboards for a couple of weeks maybe.
Not likely, but okay.
Whatever I've never run for office, I don't know. But my corporation can spend tens or hundreds of thousands of dollars in the future advocating your candidacy
right.
or opposing yours.
Right.
That's where the real money is.
Just like Don Blankenship spent $3 million in order to defeat the Supreme Court candidacy of Warren McGraw.
Which a case which is cited.
You know, he has the perfect constitutional right to do that. Mm-hmm. And of course, then 2 years later, he spent hundreds of thousands of dollars to try to elect about 47 or so candidates to the West Virginia legislature, and he lost 46 of those races.
It didn't work the second time around.
Right.
And one of the things that is true under this holding and the laws now since interpreted is whoever is paying for these ads, paying for these films, making this speech has to disclose who they are.
Right. That's correct. Certainly the federal law and most state laws have rather strong requirements for reporting and disclosure.
So like with advertisements for shampoo, you have to listen very carefully to what's being said,
right.
and you have to consider the source.
Sure, that's a major piece of campaign finance reform, is that you take into account where the money's coming from. And
I'm afraid we're out of time. Bob Bastris, Jim McLaughlin. We could talk for a long time. There's 151 pages of opinions here. Bob Bastris, Jim McLaughlin, thank you, gentlemen, for being with us.
my pleasure.
Thank you also for being with us. On behalf of the Law Works, I'm Dan Ringer. Good evening. If you want to know if you need a lawyer, you can discuss your problems with a lawyer by calling the West Virginia State Bar Helpline, toll-free, Tuesday evenings from 6 to 8 at 1-800-642-3617. On the LawWorks webpage at thelawworks.org, you'll find a listing of recent The LawWorks show topics, information on how to obtain copies of the programs, and additional information about this show's topic. You'll also find a list of legal resources that can help you answer your legal questions. If you'd like to recommend this program to a friend, you'll also find video of this program on thelawworks.org. If you would like to suggest a topic for a future The Law Works show, or if you're a school teacher and would like to receive a copy of this program for classroom use, please send us an email to thelawworks@comcast.net.
The Law Works is produced in cooperation with the West Virginia State Bar, the Mountain State Bar, and the West Virginia University College of Law. The Law Works is made possible by the generous support of the West Virginia State Bar and the Monongalia County Bar Association.
From West Virginia Public Broadcasting.